not everything is copyrightable, like something like Godzilla or Batman. Those have been distilled into, distinct enough expressions of an idea that you can protect it. But, broader things, a broad plot or a broad idea for a movie isn't necessarily going to be subject to copyright protection. And this isn't exactly the greatest example, but if you think about Romeo and Juliet, and I say it's not the greatest example because it was written so long ago, the play itself is in the public domain. William Shakespeare's legacy is not, royalties for Romeo and Juliet. But I mean, think about West Side Story. It's essentially the plot of Romeo and Juliet set in New York with, slightly different families with a bunch of music and dancing. But, it's a version of Romeo and Juliet. Romeo and Juliet itself is a version of an old Roman myth called Pyramus and Thisbe. And so the question becomes, at what point does something like that go from being a general idea or a plot into something that you can protect? And it's not always easy to tell. West Side Story, if it were made when Romeo and Juliet was still protected by copyright, it's possible that there are enough elements taken from the play and put into the movie or the stage show that it could have been a case for infringement. I mean, I really don't think so. They changed enough of it. But, there's no doubt it was at least an homage to Romeo and Juliet in some respects. There's an interesting case on this. I think two competing movies had the same basic plot outline. It's a pretty similar case in copyright law. Somebody wrote a play that became a movie, and it was called Abe's Irish Rose. And it was about a Jewish family and an Irish family, and the two kids of the families fell in love, and the families didn't like it. And again, it's it's an updating of the Romeo and Juliet story. Well, somebody else came along and made a movie, and I think it was also a show called The Coens and the Kellys, which is the same essential plot: a Jewish family and an Irish family, and the kids fall in love, and the families don't like it. And the person who wrote the first play sued the second one. And basically, what the court said is that general plot outline, that's not enough. That's not sort of distilled down enough. It's not enough of an expression of that idea for you to be able to stop anybody going forward from writing a play or a story or making a movie out of two families where the kids fall in love and the families don't like each other. I mean, copyright protection is in tension sometimes with freedom of speech, and you don't want to cut off somebody's speech to the point where they can't express new ideas or new motion pictures or books based on an old idea. So that's really what that court decision gets to. So, copyright protection. When does it kick in? When is something protected by copyright? And the law says, in the U.S. at least, copyright protection attaches the minute you do what's called fixing it in a tangible medium. The word that the law uses is fixation. Basically what that means is as soon as you for a song, as soon as you write down the notes or the words or the melody, or if you record it, if you write a poem, you can't just memorize it, you have to write it down. So as soon as it's somehow captured somewhere other than your head, you have copyright rights. And so a lot of people think you have to register something with the U.S. Copyright Office in order to get rights, and you don't necessarily. There's advantages to registration, and I'll get to that in a minute, but the minute you come up with something, as soon as you put it down on paper, as soon as you make a recording of it, you have copyright rights, and if somebody else comes along afterwards and copies it or violates one of the rights I mentioned earlier, you have a claim for infringement against them. Just to sort of illustrate this idea, getting back to the Beatles for a minute, there's a story that when Paul McCartney wrote Yesterday, he woke up and had the melody sort of fully formed in his head. And he didn't know where it came from. And he went around to a bunch of people saying, do you know this song? Because it was so familiar to him that he thought for sure it must be out there somewhere, and that he didn't come up with it. And so he went around, he sang it to everybody, and finally was able to convince himself that no, he must have come up with this himself, vision in his sleep. It wasn't some other songs that were on the radio. But when he woke up with that song in his head, and even when he went over to the piano and sort of sketched it out and played it and fleshed out the song a little bit, he still didn't have his copyright rights yet under U.S. law because he hadn't recorded it or he hadn't written it down. contrast, there's a story about how Keith Richards wrote Satisfaction. This was actually the same year, I think. And the story goes, and the legend goes, that he woke up in the middle of the night, and without remembering it the next morning, he turned on a tape recorder, picked up his guitar, and played the main riff to Satisfaction, and said or sang into the tape recorder, "I can't get no satisfaction," and then fell back asleep. And the next morning, he listened to the tape. He didn't have any recollection of doing it for whatever reasons Keith Richards may have had. But the instant he got up and recorded that into the tape recorder, he had copyright rights. And so, you know, just sort of an interesting illustration of when the rights attach. So registration. Like I said, you don't have to register a copyright to have rights, but it's really encouraged, because when you sue somebody for copyright infringement, if you don't have it registered, essentially you're going to have to prove how you were damaged by the infringement. You're going to have to demonstrate how somebody else's use of this harmed you, and you're going to have to somehow quantify that. You know, your outrage at somebody stealing your idea is not going to be quite enough. You're going to have to show that, you know, this person stole my idea and sold 50,000 copies of a book based on my idea. That's my measure of damages. That's not always easy to prove. But if you register a copyright before the infringement occurs, then the law already sets some damages. And so, you know, you hear about these lawsuits, and they've tailed off a little bit, where the recording industry would sue somebody who downloaded a bunch of songs from the internet, and they'd get these verdicts in millions of dollars. Well, they registered all those songs, and so they could go to the judge and say, listen, the statute says I can get as much as $150,000 per song for somebody who downloaded it illegally. Because it was registered, because that's written in the law, they didn't have to prove anything. And so it doesn't take too long at $150,000 a pop to get some pretty big damages. And you know, that's a real reason to register, as opposed to relying on the rights that occur naturally.
Okay, so you're talking music. What about formulas and things like that? Someone comes up with formulas, creates something.
Formula, like, I mean,
skincare.
I mean, you know, the classic example, I think, of what you're talking about is the formula for Coca-Cola, or a
You
recipe.
gotta put part A with part B with part C to come up with the final product. You know, say it's your creation, and how would you roll it out? Is that within the copyright, trademark, or patent area?
That's, it could be more of a patent issue, but it's really, something like that is largely going to be covered by trade secret, which is the fourth branch of IP law, SIMI IP law, and that really, you know, it's more like sort of private business information that you keep private to your business and don't disclose. You can have some rights in that, and it's, you know, you can take action.
The federal government wants you to disclose everything that goes into a product.
Well, you know, for example, for pharmaceuticals, you know,
I'm talking pharmaceuticals, though. I understand what you're saying, but you still have to label whatever you have.
you have to label, but you know, it's not, the quantities aren't necessarily labeled. I mean, the ingredients in Coke are on the can, but the formula is still the most closely guarded secret in the world, so some people say. And so, you know, there's some loopholes there, natural flavoring, or you know, whatever, those kind of things. You can put at the end of a recipe, and so you're not saying what the secret ingredient in Coke is. And so, you know, it really depends on exactly what you're doing, but some of it could be protected by patent, but a lot of it is going to be protected by trade secret. Recipes, formulas, things like that, those aren't going to fall under copyright. Those are not going to fall under copyright. So how long does copyright last? It's not indefinite, although Congress has lately taken to extending the term of copyright as soon as, you know, Disney's about to lose Mickey Mouse. They decided they want to extend it for another 20 years. But basically, the way it stands now is the life of the author plus 70 years. So if you write the song, you know, your heirs can maintain copyright control for another 70 years after you die. If it's a corporate author, you know, if Disney's in employees make film, Disney's going to own the copyright in that. And so basically, that's going to be 95 years from publication or 120 years from creation if you don't publish it. So, you know, companies, you know, the company's not going to die, so they just fix it a certain number of years. So 95 years for Mickey Mouse, you know, life of the author plus 70 years for a song somebody wrote.
Well, could say the family of the songwriter, could they extend that beyond 70 years? Is there anything they can do?
You can't renew copyright anymore. It used to be that you, in an older scheme, every 14 years or so you'd have to apply and renew. The way they've done it now is it's a flat term, life of the author plus 70 years, and you don't have to file any renewals or extensions, unlike Trademark, which we'll talk about in a minute. But Congress every now and then just decides they're going to automatically extend everything, and so if they do that and your work hasn't slipped into the public domain, the last time this happened was, I believe, late 90s, early 2000s. Congress extended the term, and everybody who had a copyright in force, you know, was automatically extended, and that's the way it's going to happen in the future, because there's no renewal process really anymore. There used to be.
Like Jingle Bells.
Jingle Bell, you know, whoever owns the rights to Jingle Bells, and I think it's still protected. I mean, I think it was written in the 20th century. I think it's the family of the man who composed it, which is Savannah, right? Am I right?
Fair point.
Family or the heirs or whoever he assigned the rights to, or you know, willed the rights to, own that, and they will continue to own it until the term expires.
Well, I'm thinking 70 years is probably past.
I'm just, you know, it's probably getting close. But then it'll pass into the public domain, and once the work is in the public domain, then anybody can use it without restriction. It's not subject to copyright protection. But companies who have invested a lot in intellectual property dating back many years lobby Congress very hard for these extensions.
How do you define what's in the public domain?
That's tricky, and it's a problem because it's not always easy to know. And you know, another problem similar to that is what they call these orphan works, where you can't track down the author, you can't figure out who owns something, if they own it, you can't figure out when it was written, and it's a gray area that Congress has talked about trying to address, and the Library of Congress is falling under their purview. They've tried to come up with some rules as to how to address things like that. Nobody's really been able to agree on a solution. And, you know, unless you can, you know, if it's registered, you can look it up on the Library of Congress website and figure out when it was registered, and then you can do the math and figure out whether it's fallen into the public domain. But if it's not registered, and you don't know when it was written, then, you know, you're kind of proceeding at your peril a little bit.
Sir, if you do a revised or an upgraded version of, say, a movie or a character, does that then extend the copyright years?
Not necessarily. I mean, what you get is the particular work, you will get that term of years. So, you know, go back to Batman for a minute. Copyright the character of Batman is going to, that term is going to begin when the first Batman comic book was created, which was, you know, sometime in the 20th century. And it's, you know, 95 years from when Batman was created. I don't know if it was the 30s or 40s, but, you know, it's not going to be too long before Batman is slipping into the public domain, which is probably why they're making one Batman movie a year right now. But the sort of fourth or fifth Batman movie that comes along is not going to extend that. But, you know, the new Batman movie that comes out, I think this year, is going to have its own term, but that's only going to apply to that particular film. It's not going to apply and relate back to the original character, but that particular movie, that particular plot, everything that you can say is copyrightable about that film, including just making a rogue copy of it by burning a DVD, that's going to have the, you know, in this case, the 95-year term. Yes.
Thinking of Disney, especially, Disney owns certain copyright rights to classic fairy tales and folk tales like Beauty and the Beast and Pocahontas, and even more recently, Winnie the Pooh. I have a client who's a professional storyteller, and some of these characters came up in her website. So can I mention Beauty and the Beast without violating Disney's copyright? Because it pre-existed Disney. As long as I don't say Disney's Beauty and the Beast.
It kind of depends on which of those that you're talking about. Some of the older fairy tales, Disney doesn't own the rights to those stories. What they own is the rights to their particular versions of it. So, I mean, I don't think Disney owns the story of Cinderella, but, you know, they've invested a lot of time and money in that particular version of the Cinderella character. And so, and they have their whole Disney princesses thing, and, you know, each one is drawn differently, and that character is strongly, you know, identifiable. And so, you know, I don't know if this is true, but I've heard that there are some, you know, daycare centers or kindergartens that would get sued by Disney because they put like a big Mickey Mouse poster on the wall.
Sure, yeah.
Or they put Cinderella on the wall. Now they couldn't sue Disney, or Disney couldn't sue the daycare center for having the kids gather around and tell the story of Cinderella.
Right.
But if you took that particular Disney version of Cinderella, if you made a poster out of that particular character, and I can't remember which one she is right now, but, you know, blonde hair and a blue dress.
Yes.
It's pretty identifiable. That's what Disney is going to be able to protect. But Winnie the Pooh, for example, they might own exclusively because that was written, you know, by, you know, those were books authored, I think, in the early 20th century.
Yes.
And so they probably have bought the rights from the film, and they own that.
Okay.
And so nobody else can do Winnie the Pooh. But, you know, the Hans Christian Andersen stuff, the Grimm fairy tales, you know, those things are public domain, but Disney is aggressive about this.
Okay. So you might be able to say the words "a classic Cinderella tale,"
Yes.
but you wouldn't be able to say it's like Winnie the Pooh getting his head stuck in a honey jar.
I mean,
necessarily. You'd be more careful.
You'd want to be more careful
Okay.
about that. You know, some of this is about practicality. The likelihood of getting sued for telling the Winnie the Pooh story is minimal, but if you want to make your own Winnie the Pooh cartoon, if you want to put on a play about Winnie the Pooh, you know, Disney would be able to stop you, most likely. Yes.
I was told on my treatises that if you were doing public speaking, you're telling stories. If you shorten the stories, a few paragraphs in your thing, that they can't come after you for that. It's an abbreviated version of their story.
Well, that sort of leads nicely into the next topic for copyright, which is fair use.
That's what I'm talking about.
And basically, fair use is a defense to copyright infringement. Meaning you can take something that is clearly protected by copyright and use it if it's what's considered a fair use. And it really is entirely dependent on the context and circumstances. So, you know, if, for example, you're writing a book review or you're giving a lecture on a particular book and you want to quote from it to illustrate what you're talking about, you know, book reviews are widely considered to be fair use if you sort of quote a little bit from it. But it really is going to be context dependent. You know, there's certain favored classes of uses as fair use. So criticism, academia, you know, news reporting, things like that. If you quote from a book in furtherance of your scholarship, that's not going to be a copyright violation as long as you don't take so much of the book that you're talking about that they just buy your, you know, book of criticism about the book as opposed to the original. But it's not always absolute. One of the classic cases about what you're talking about has to do with, I believe it was Gerald Ford's autobiography. It was coming out and he talked a lot. There was, like, the section that everybody was interested in was when he talked about his decision to pardon Richard Nixon for the Watergate. And this went up to the Supreme Court because a magazine, I believe it was The Nation, I can't remember, got a copy of the book before it was published somehow. And they wrote an article about it, and book reviews are legit, but what they did was they went into the book and they took the relevant passages about the Watergate issue, which is what everybody wanted to know, and the Supreme Court said, well, that didn't amount to a whole lot of the book. You know, if you measure it by pages or by words, it's not a substantial portion of the book. It's not half, it's not a quarter, it's not even 10% of the book. It's really only a few pages, but it was so much what people were interested in that basically what the magazine did was sort of usurp the market for the publication of the book. And they said that was not fair use. maybe quote a little bit from it, you can talk about it, you can describe it a little bit, and you read some book reviews sometimes that really get extensively into the plot of a fiction or a nonfiction book and then dissect it and put their own take on it. But what you can't do is really just duplicate the essence of the book such that nobody's going to read the original book. And it's a fuzzy line, and it's really hard to tell what's going to apply when. And so I would be really hesitant to give you sort of a general set of guidelines as to when something is fair use and when it's not, because it can really be tricky. I mean, I think if you want to quote something, a good rule of thumb is don't take any more than what you absolutely need to make your point, and you should really only do it in the context of, you know, discussing it, talking about it, criticizing it, as opposed to just sort of telling the story or reading the passage because you like it, because it's entertaining.
And when you do that, should you give the author credit?
I mean, you don't necessarily have to do that. I mean, you know, you're treading into plagiarism a little bit when you talk about getting credit, which isn't really a species of copyright. You know, that's more of sort of an ethical issue. But you give credit, but that's not really going to be the determining factor as to whether something's fair use.
What about a tour based on a map? Like a guided tour that somebody's making money off of based on a map that was published recently.
So are you asking if the map's an infringement or if the
The tour is infringement on the copyright of the map.
You know, that's an interesting one, and I don't think I know the answer to that off the top of my head. My guess would be that the tour itself, giving the tour, even if the tour guide was referring to a map, would not be an infringement. But, you know, I mean, the way tours can be subject to copyright protection, I mean, I don't know how many there are, but there's at least one and maybe two ghost tours in Savannah. And, you know, if there was one ghost tour company out there and somebody else said, this is a great idea, it's making a lot of money, I want to do a ghost tour. If that person went on the ghost tour, took notes of everything the tour guide said, went to the exact locations, or told the same stories, you know, I could see how that could end up being a copyright infringement because, you know, that's almost like a performance. And I could see how you could get to a point where you'd be infringing on that. But just to, you know, just to give a tour of Savannah based on, you know, a recently published map of the historic district, I don't think so, but I don't want to give an absolute answer because if you went to locations that were specifically highlighted on the map, and only those locations, I don't know. I'd have to do a little bit of research. It's an interesting question.
Does that go back to the facts issue, that if someone is on a tour and they're just reciting facts that are common knowledge, that if you rearrange it to your own order, you're not infringing on the other guy that does the same thing?
And that's true. I mean, you know, if you're telling the historic stories behind these old buildings in Savannah, nobody owns the copyright in you know, in the story of General Sherman staying at whichever house that is downtown. I can't remember. But, you know, if there's a particular anecdote that somebody has developed, you know, if somebody wrote their own story about it and embellished it in their own way, and you basically sort of retold that verbatim, then that's when you're getting into a possible area of copyright infringement. That's why, you know, a biography of somebody, that's all fact. And the facts that are in that biography aren't going to be subject to copyright protection. But you can't just take a biography off the shelf, Xerox all the pages, slap a new cover on it, and publish it on your own, because there was a, you know, there's a lot of expression of those particular ideas. The way the author conveyed them, the way he arranged them, you know, the way he tells the story is his own narrative is what's going to be protectable by copyright. But the fact that somebody was born here and died here and, you know, did A, B, and C during his life, those are not going to be subject to copyright.
Now, there is a good bit of leeway with titles, too.
Titles is interesting. You don't necessarily own, and it's more of a trademark issue, you don't get trademark rights in a title automatically. A title really has to develop some rights over time and have it come to identify a particular work before you can say you can't title this the same title. And it's really kind of hard to do that.
Moon River Grain Company, for example.
Exactly. I mean, you know, I don't know if there's more than one song called Moon River, but, you know, I can think of a few other songs out there that have the same title but are different songs, entirely different songs. So, you know, if you title you know, there's the old song in the 60s called Wild Thing by the Trogs. And then the late 80s or early 90s, there was a rap song called Wild Thing that had its own copyright issues because it sampled, you know, Van Halen, I think. But it's not like the Trogs could sue the rap artist for using that title, because you know, it's very hard to get copyright rights in just a couple of words. It has to be a little more fulsome than that. But you can get some trademark rights, but it really has to do with what the words are identifying, and whether it's going to confuse the public. And something like two songs that are totally different, the likelihood of confusion is very low.
What is the difference between copyright and trademark?
Well, yeah, this is a good segue into trademark, I think. So trademark is really, it has its origins in consumer protection. And that's not really necessarily the way it's practiced now. Now companies sort of protect their trademark rights for their own purposes because they want to develop a strong brand and prevent somebody from trading off of it. But really at its core, it's designed to be something that protects consumers, so that if you see something out there that's labeled with a particular brand, you can buy it and have confidence that it's, you know, the same product with that brand that you saw somewhere else and whose quality you trust, and et cetera. And so basically, you know, trademark words, it's, you know, logos or devices that are used to identify goods and services and their source of origin. So it's really about identifying somebody's business, a particular product they sell, a particular service they offer. So, you know, something can be subject to copyright and trademark. Somebody could design a logo, and the graphic designer who designs the logo, she can own the copyright rights in that. But until somebody starts using that to brand a particular product, there are not going to be any trademark rights. It's only when the public starts to associate that logo with the products that are being sold that trademark rights develop. And trademark rights are developed through use. They're not automatic. As soon as you come up with the brand for your company, you don't automatically have trademark rights. You only have trademark rights once you start to use it to promote your company. Yeah.
So if you're a SCAD student trying to shop a cartoon that's built around a cast of characters and has a specific name, what would you suggest for obviously the low budget that they would have to, as they start to shop that around the publishers? What's the best route for them to go? Should they trademark their you know, if it's Rugrats, and then how do they protect all the individual characters under that Rugrats trademark? So what's the best, most economical way for them to go to do that?
Well, they're not going to really have trademark rights until it's used so much that the title is immediately sort of evocative of
Sure,
the
but
particular
if they're trying to shop it to publishers,
if they're trying to shop it to publishers, I mean, you can get into copyright and trademark issues here. You could file an application to register the word Rugrats with the trademark office before you've even started using it. That doesn't confer trademark rights, but it kind of reserves the name for you. Once you start using it, once it starts getting used in public, you can then start to develop some trademark
right? But they
rights.
still, but then it becomes cost prohibitive to do a character mark and a word mark for every one of the characters. So there's 5 characters. What's the best way to economically do that?
Well, when you get into the characters, it's probably going to be more of a copyright issue. So if you've made a short film, a short animated film, and you want to protect your rights, I think that the most cost-effective thing to do is going to be to register that film with copyright on it.
Or the strip?
Yes, or one of the strips or something like that. So
And that would protect the individual characters as well?
It would, except that characters that are subject to copyright protection really are those characters that tend to be developed over time. I don't think you get immediate copyright protection in the first, you know, comic strip that you put out there, like the very first Snoopy Peanuts strip. You know, Snoopy was in that, but I don't think the Snoopy character was developed enough at that point to merit his own copyright protection.
Okay.
But the story, you know, the images, the way it's expressed, you can get some copyright rights in that to prevent somebody from copying your drawing style and, you know, the plot and the setting and everything like that in a particular way that you've done it. And it's pretty cheap to register a copyright. It's,
okay.
You know, you can do it online in a lot of cases, and it's about $35, and you know, it takes a little bit of navigating to navigate the system, but that's not really cost prohibitive. Trademark registrations are more expensive,
Right.
but not.
So you would say don't worry about the trademark at that point in time, just do the copyright on the character?
I would say if you create something and you're really going to try to monetize it, and you're worried about people infringing it, register the copyright. if you think that you're going to market it under a particular brand, I mean, you know, Rugrats, the cartoon, when it started, there probably weren't a lot of, you know, trademark rights to be associated with that. But once it became popular with kids and they wanted, you know, a backpack with the Rugrats on it, or they wanted a notebook or a pencil or something like that, you know, then you start to develop trademark rights, and people associate Rugrats and kids products with this cartoon. And so you could reserve with the trademark office Rugrats, you know, on pencils and notebooks, but until you start making that, or until people start associating that with those types of goods, you're not going to really have trademark rights. But you can, with the trademark office, file an application before you've even started using it. But you know, you're not going to get trademark rights in it until you use it, and they won't grant the registration unless you use it within, you know, 3 years after they've allowed the.
So if you were the Angry Bird guys, and you knew now what you didn't know back when you first started, what would you have? How could they have ensured protection of the Angry Bird franchise? Because it happened so fast.
I mean, you know, they had copyright protection immediately, and I think they're from Europe, and so I don't know exactly, you know, what the.
But if they were okay with just a copyright, you didn't have to worry about the trademark.
I think so, because, you know, that particular drawing of the different birds, you know, it's a copyright violation to take something that looks so much like the, you know, the birds or the pigs or whatever and put it on something else.
Okay.
It's, you know, as soon as somebody's copied it, it's an infringement.
Okay.
Registering it quickly is going to have some benefits, because then you can say, well, you put it on a backpack and you sold one of them for $5, but, you know, you did that with bad intent to trade off my success, and it was a copying, and I registered it, and therefore you know, my damages are $150,000.
Registered as a copyright, not as a trademark or a character mark.
Yes.
Okay, good, thank you.
You get a graphic designer to create a logo. Who owns that right?
It depends on the arrangement, and you know, this is an excellent question, because these things can be disputed, and my advice in situations like that is establish an understanding in writing up front. The basic rule is that if you know you own a business and one of your employees creates a logo in the course of his or her work, then you, the business owner, are going to own that. But if you employ an independent contractor or, you know, a graphic design firm to design a logo for you, if you ask them to do that, unless you specifically obtain the copyrights as part of that process, you're not going to own it.
But if they give you a letter that states that they created this for you and your business, and you now have the right to, I can't remember the jargon, but I've gotten that done. Then
yeah, and you know, what you really want is an assignment of the rights, and that can be effected through a letter that says, you know, if you get them to send you a letter that says, as you requested, I created this thing, you know, in exchange for $500, and you know, as we agreed, you know, all the rights in this are yours forever. That's probably enough to assign you the rights, and you couldn't really challenge it. But you know, it helps to have something a little more formal, something that is a little more resembles a legal document. And graphic design firms should have some stock forms, license agreements, or assignment agreements, depending on the situation. But if they don't and they don't offer it, you need to think about how to get that done, how to make sure that you're getting the rights you need. Because
Find a new designer.
Pardon?
If they don't offer it, find a new designer.
Yeah, exactly. I mean, you know, you need to secure the rights that you need. You know, you don't want to pay them to design something for you and then start to use it, and then they come in and say, well, you know, I never assigned you the copyright. You have to stop. You're infringing my rights. I mean, you know, sometimes there's an implicit understanding. I paid you $500. You gave me this logo. You might be able to argue that it was implicit that I was going to be able to use this for these purposes, but you know, you don't have it in writing. It can be troublesome if you do something with it that is beyond the scope of what you were talking about when you hired them to create it. You know, you wanted it for a logo for your business. You want to be able to prevent them from using it for something else. For, you know, you created this little design. Can the graphic designer go off and use it for his or her own purposes, to put it on his or her business, to, you know, yeah, unless you get the rights and prevent them from doing that. So get that in writing and get it up front. It should be the key element, you know, additional price and negotiation or something like that.
All right, one more question. Product design. So just if they're designing a unique product, but it's not creating any you know, proprietary technology or whatever, it just looks different than what's out there, is it okay to go with just copyright, or do they need to do provisional patent, or what's the trademark
I
question?
suppose it depends on what exactly. you're
So it's a
talking-
new spoon. It's a spoon that has a specific angles that's all in a CAD drawing.
For something like that, copyright will not attach to anything that is functional.
Okay.
So to the extent that, you know, the functional elements of the spoon are not going to be protected by copyright.
Right.
But, you know, if there's some ornamentation on it, if if the handle is split into 3 pieces in a certain way that is entirely a design element, that could be subject to copyright protection.
Once again, the SCAD question, what's the most economical as they start to shop that around, they take the spoon to Oneida? How do they protect that Oneida is not going to take their design?
I mean, that gets very tricky, and if what they have done is enough to merit copyright protection, then they should try to register it.
So copyright is a start, but
Yeah.
trademark would probably be better in the long
I
run.
mean, trademark is a way to protect your brand. I mean, you know, I have a client who makes these beautiful lamps. He's gonna, you know, try to buy the lamp that's his brand. You don't want the knockoff, you want the original. And so that's sort of a branding strategy, and that's establishing a trademark and developing your rights and making sure that, you know, when people go out to buy this fancy lamp, that they
Right.
want to buy an original. Somebody else could even under copyright protection, do something similar, but not so similar that it's a copying of the design, and it could be a knockoff. I mean, you know.
Okay. And so provisional patent is not necessary in that case.
I mean, it really depends on what the object is. I don't think you're going to get a patent on a new kind of spoon. I mean,
Right.
It's just, you know, the
Right.
spoon is, you know, there's an obviousness standard in patent law where, you know, if there's spoons out there, just because the spoon has a funky handle doesn't mean you're going to get a patent on that
Right.
spoon.
Okay, thank you.
Yes.
As a practical matter, most of the knockoffs come from the Orient, I think. How do you enforce it? Where is your target? What do you do?
Well, you know, that's a species of trademark infringement, counterfeiting. And, you know, the U.S. Customs has a lot to do with that on the importation side. They will seize goods that come over the border that are counterfeit goods, or, you know, they also have some authority in copyright as well. And so, you know, if you're a trademark owner, you're going to want U.S. Customs to be on the lookout for counterfeit versions of your brand. And, you know, other than that, what you can do is, if the goods make their way into the U.S. and, you know that, you know, in New York on Canal Street, somebody's out there selling, you know, fake Oakley sunglasses that everybody knows aren't Oakleys because they're $2 a pair, then you're going to have to go after the person who's down there selling them and maybe work your way up onto a supplier. I mean, you have to be diligent in protecting your brand. I mean, that's the thing about trademark rights, is you hear about trademark owners suing people, and sometimes you think, you know, why you messing with the little guy? But if you don't protect your trademark rights, you can use them. Aspirin used to be a brand, and now it's a generic term that means that particular type of drug. But it used to be a protected brand, but they didn't. You know, the company who owned it didn't take the steps to keep other people from using it, and they lost rights to it. That's why Xerox gets all crazy when you say, I'm going to make a Xerox of this. No, no, no. You're going to use a Xerox copy machine to make a photocopy. Hand me a piece of Kleenex. No, hand me a piece of Kleenex brand tissue. You know, I mean, that's why you see these people out there sort of making those, you know, ridiculous sounding statements, is because they want to preserve their rights. You have to police your trademark rights to keep them.
Sometimes when I'm naming a product or service, or even doing a theme line for a client, I will go to USP, the U.S. Patent and Trade Office.gov, just because that's all I know to do to feel like I'm doing my professional responsibility for making a recommendation. Is there anything else I should be doing? Are there any things to be aware of on that search system?
There are some limitations to that system. It's a good first cut. It's very useful for identifying exact matches.
Mm-hmm.
You know, if you want to try and figure out whether somebody else is using an identical mark for the same services, you can go on the USPTO's website and find out, you know, car manufacturer wants to come out with, you know, Apple cars as opposed to Apple computers or something like that. You can type in Apple, and you can see if anybody's registered or applied to register that mark for use with automobile.
Okay.
And that's useful that way. But it can get a little tricky because it's hard to do a search for something that is similar enough to be a problem, but isn't spelled exactly the same way, or, you know, might be similar in meaning and overall impression, but isn't the exact same letters. And so, you know, what we do when we help folks prosecute trademarks is we'll say, listen, if you want to be sure that nobody else out there is, or sure as you can be that nobody else out there is using the mark that you want to adopt, and a lot of times if you're launching a flagship brand and you're investing a lot of money in branding, you're going to want to make sure up front. What we do is we commission a trademark search from a research company, and they search the USPTO database, they search the state trademark registration databases for all 50 states. They do, they search trade publications, they do targeted internet searches, they search business records, and they do all this in a manner that is designed to capture as much as they can without getting too much information in the process. And so there's some inherent limitations in there, but you know, I'll order a trademark search and I get a binder that's about like that, filled with information, and then the attorney's job is to go through all of that and flag the marks that look like they could be a problem, and then consider them and say, well, you know, you shouldn't adopt the mark because this one here is going to be a real problem. They could make you stop it. Or this one looks similar, but in my opinion, it's not going to be a problem because of X, Y, and Z. And so that's the real way to make sure. The USPTO is a good place to start, but not everybody registers their trademarks.
Okay.
So,
and I always say it's preliminary and should not be considered legal advice.
no, I think that's
Call your lawyer.
Yeah.
Okay, one more question. I'm going to have to.
There are a lot of articles recently over the past year in Wall Street Journal about the registration of sounds, like, for example, the NBC chimes, in colors, like the red, shade of red Coke uses, and yellow for Coke, and so on. Have you had any experience with people registering colors of sounds and taste?
Those, I mean, I don't know that you can register a taste necessarily, but you can, I mean, the one I've heard about recently, the sounds, is that Law and Order sound. I can't vocalize it, but it's that weird note that they play when they come back from commercial or they're transitioning. I believe they have a trademark in that sound. And if it's something unique and it identifies a certain thing, then you can get a trademark in it. I had a client when I was in DC that they manufactured something that it was like it was for trucking companies, and it was some putty that you applied to the tires to fix tires or something like that. And he asked if they could trademark the color of this. And because the color was non-functional, because it wasn't, you know, it's not that the chemical composition that they used to make their product resulted in a green putty, it's because they decided to color it green. They could establish rights in that because, you know, the putty might be white in nature if you just combine the ingredients, but they dye it green, it's out there, you know, all the suppliers distribute this, people use it, and they start to associate this green putty with a particular product. Well then, yeah, green, you know, fix-a-flat putty can be trademarked. The color green, if you use it, if it's non-functional, you can get a trademark in that. You know, I read something else recently about the soles of certain designer shoes. There's like a bright pink sole, and there was a trademark dispute over whether somebody else could make a pink sole. I mean, it was this high fashion thing, and you know, you could spot it on the runway, and a mile away you could see somebody with these pink soles of their shoes, and they were arguing that, you know, this pink color on the bottom of the shoes identifies our particular brand of shoes. It's a trademark issue, and somebody, you know, has no reason to make a pink sole other than to try and trade off our goodwill. And so that, you know, that's another example of where you might be able to establish trademark